Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hi, my name is Jason Lazarus, CEO of Synergy Settlement Services, and I want to welcome you to this month's Third Thursday webinar. The webinar is The Art of Structuring a Settlement. While structured settlements aren't typically a subject we cover, this presentation is a little more broad in scope and covers ethical duties, along with some nuanced topics about structured settlements, along with qualified settlement funds, which are a unique tool that can be used as part of a holistic plan to address a client's needs. Before getting into some of the more technical issues, I wanted to talk broadly about the obligations of a personal injury attorney in terms of advising their clients about the different legal issues that arise at settlement, because that's an important starting point. When it comes to ethical issues and settlement, there really are two questions that plaintiff attorneys should ask themselves. What are my obligations to advise the client regarding financial options at settlement? That's the first question. And the second one is, what are my obligations to advise the client regarding public assistance preservation? When it comes to the financial options at settlement, there are two laws or two legal concepts that should be explained to a client, because as a lawyer who represents an injury victim, you have that obligation to explain legal issues to that client so that they can make an informed decision. Those two are Section 104A2 of the Internal Revenue Code, which provides different options in terms of how a settlement can be received, gives the client basically the option to receive a lump sum, which is not taxable, or a structured settlement that is tax-free. And then constructive receipt, because constructive receipt, once triggered, basically impairs the client's ability to enter into a structured settlement. So understanding that once the money's flowed into your trust account, that's a problem. And then there's several different statutes that pertain to preservation of government assistance. The 1396 PD4 has got to do with special needs trust. The MSP is an important topic these days to discuss with clients about the implications of future Medicare benefits. And there's a couple of cases, Grillo, French, and Saunders. Those are all cases where trial attorneys were sued either for not providing counsel and explaining options as it relates to the financial perspective or public assistance preservation. So there's definitely case law out there that has held trial lawyers responsible for legal malpractice for failing to advise their clients. And if you take a look at the model rules of professional conduct, informed consent, that's one where you've got to make sure that that client has gotten the explanation about the risks and alternatives to make sure that they understand what they're doing in terms of their decisions. But also Model Rule 2.1 that allows for consultation with a professional in another field. That's an important one, because when you take a look at some of these quotes at the bottom, these are other lawyers talking about making sure that clients understand the options about structured settlements trusts and the loss of public benefits. the ABA's ethical guidelines for settlement negotiations, making sure that the client's interests are best served, which includes implications of tax. These are all issues that are important for you to know in terms of being able to adequately convey it to the client and make sure that they make an informed decision. As an expert in this field, so in my opinion, the laws that impact settlement have to be explained to that client. If you fail to do that, there's no way that that client can make an informed decision, and there's a loss of an opportunity to exercise certain options available under the law, and then consequently damages can flow from that. And that Grillo case really, I think, is one where if you look at what happened in that case, and I didn't go into detail about it, but really it was a case where basically their experts were not brought in to advise, and ultimately that client lost the benefit of having a tax-free structured settlement and having trusts and different things that would have protected the minor settlement. And really, as I said earlier, if you as the lawyer or your law firm does not address these issues, who is going to do so? And there really is a very low threshold when it comes to these discussions, because if it's simply about public assistance preservation, then the settlement could be $5,000 and still impair that client's ability to receive benefits, because the SSI and Medicaid cap is $2,000 if you're single. So very small amounts of money can cause problems and require the counseling for the client so that they understand what's going to happen once they walk out the door with the check. So all of that leads me to one suggestion, one piece of advice. I think it's really important to make sure that you either have the requisite knowledge or consult with experts so that you can advise the client about these issues. And then you want to document your files. So you want to have something, either a letter or something that the client signs that says, I understand all of these issues, and here's why I'm deciding to do what I'm doing. You don't have to force them to do anything. It's just documenting ultimately that they understood their options and elected to do whatever they've decided to do. That's just good practice and making sure that your files are closed compliantly. Now that we've talked about the ethical issues that concern advising clients about their financial options, let's talk about those financial options in a little more detail. As you know, when a personal injury case settles, the client has different options in terms of what to do with the recovery. The first option is simply to take the settlement monies in a lump sum and manage it on their own. Anecdotal evidence shows that 90% of those that choose that option wind up with nothing within 5 years of settlement, which is a pretty terrible statistic in terms of the ability of clients to manage their recoveries. And that's, a variety of reasons, either poor investment choices, using the money to start a business that fails, helping family members when they really should be using that recovery for their own care. Second option is structured settlements, which were created really in response to the problems that can arise when a client takes a lump sum. So with a structured settlement annuity, they receive future periodic payments via an annuity, which are income tax free. The last option is a trust, and trusts are great solutions for clients who are not great at managing their own recoveries, or they need to preserve public assistance. In many cases, there's a combination of different options that are exercised. So it can be part of the settlement to lump sum, part of it in a structured settlement annuity, part of it in a trust. So you might ask yourself, why would a structured settlement be utilized? And really, it's because it's the cornerstone of most good financial settlement plans, because you want to have some fixed income or an investment vehicle that has a very low expense, is income tax free, and isn't subject to wild market fluctuation. And I chose to do a structured settlement when I received a personal injury settlement arising out of an accident I was involved with in 2016 when I was struck by a car while cycling. And I did part of the money in a lump sum, part of it in a structured settlement. I also set up a trust to pay for my future medical because I do believe that in situations such as that, it's really the best way to plan for your future once you've had a recovery. There are a couple different structured settlement options today. There is the traditional fixed, but then there's also the ILAPA product, which is an equity indexed structured settlement annuity. It does have a cap on the investment gains, but there is a brand new product called iStructure, which is offered by Independent Life that has no cap whatsoever. So these equity indexed structured settlement options give a little more potential upside than the traditional fixed, but same benefits, income tax free, no ongoing expenses for management of the recovery. So great options overall. There are some personal injury cases and settlements that are just perfect candidates for utilizing a structured settlement as part of a broader settlement plan. The first is when you've got the need for a trust or say a special needs trust where someone's on Medicaid. So the monies that are structured will flow into the trust, and most trustees don't charge a fee on monies that are outside of the trust, only as they flow into the trust. So using a structured settlement makes for a very efficient way of funding the trust. One, you're not paying tax on the gains like you would if the money is sitting inside of the trust, and you're not paying trustee fees. So it really is a great way to fund a trust. Second is for Medicare set-aside. So the Medicare set-aside is lowered overall by utilizing a structured settlement because one, you get an age rating, which means that life expectancy is lower, and that's how MSAs are calculated, but also typically it's about a 20 to 30% cost savings funding over time versus a lump sum. And you can use a structured settlement to also fund the administrative expenses for that Medicare set-aside. Third type of case is a case where you've got a large life care plan and catastrophic damages that need to be funded because those are quantifiable and you can set up payment streams that match up with the needs. The fourth one is minors and incompetence. Obviously, with minors and incompetence, it can avoid a guardianship in many jurisdictions. It lowers the overall cost, provides greater flexibility. It's got the income tax-free benefit. It's also got inherent protections, typically under common law against creditor claims and judgments to some extent. So there are some really good asset protection reasons why you want to do it for minors and incompetence. And then lastly, when you've got specific known quantifiable damages, like say someone needs a handicapped equipped vehicle every 3 to 5 years, you could set up a structured settlement payment to match up with meeting the need for future dollars to pay for those kinds of acquisition costs. One thing to be aware of is that there are some areas of concern and issues that you should be aware of as a trial lawyer when it comes to a structured settlement. First is rated ages and annuity rates, because the combination of those two factors, that's what determines what the best deal possible is for the client in the marketplace. So you really have to understand when you're going out to the market that you have to look at the combination of different factors to get the best possible deal for the client. Next, you want to look at reducing default risk. So when a structured settlement is done, you can spread premium amongst different life insurance companies. It doesn't all have to go with one, and you can spread that premium around based on the strength or the financial ratings of those life companies, which is the third area of concern. You want to make sure that the money is being placed with a really rock solid life insurance company, companies like Berkshire Hathaway, New York Life, Pacific Life, MetLife, Prudential, big well-known companies, and you can spread the premium around amongst those companies. But of course, you have to take into account the rated ages and annuity rates, because some of these companies have sweet spots. They're better with life contingent payments versus just for a period certain or future lump sums. They all have their sweet spots. So you want to try and develop a plan when you're using structured settlements that takes advantage of the arbitrage. Liquidity at death is an important thing. So in certain circumstances, you don't want the future periodic payments to continue. There's a commutation option that can be exercised, which means at death, a lump sum is paid to the beneficiaries instead of the payments continuing on into the future after the structured settlement recipient dies. And then lastly, constructive receipt. That's something that you can trigger by taking money into your trust account, which then makes it either impossible to do a structured settlement or much more difficult. So a conversation about structured settlements would not be complete without talking about the opportunity that you as a trial lawyer have to defer taxation of contingent legal fees using structured settlement annuities. So attorney fee structures are the same exact product that's used for personal injury settlements, except instead of it being completely tax-free, it's a pre-tax and tax-deferred vehicle for contingent legal fees. And you can set up these structure just like any other structured settlement where you can do immediate payments or deferred payments. You could do it lump sums, period certain, or lifetime. But these are done as part of the settlement and it's part of the settlement documents. And by doing it this way, you avoid constructive receipt, you defer the fees along with the taxes, and your investment grows tax deferred. Payouts from the fee structure in the future are taxable in the year received. And you can structure all or part of a fee. So I work with a personal injury law firm that over time took different portions of their fee and structured them and created quite a great cash flow once they got to retirement age, where these fee structures began to pay out. So you can layer them with different settlements and different amounts of money. The key is you've got to elect it at the time of settlement. So the case really for structuring fees is because you want to have some of your investments in a fixed income vehicle. So why not do it in a pre-tax and tax deferred way? And with attorney fee structures, you can invest as little as $10,000 of your fees, because as I just said in the previous slide, you can structure all or portion of a fee. But what that allows you to do is really take control over spikes in income and even out taxation. So there are two different fee structure vehicles. One is the traditional fixed annuity, which does not fluctuate, very low risk, because really the only investment risk is if the life insurance company went out of business. The rates are going to be similar to bonds and other long-term debt instruments. The equity indexed fee structures are a little bit more aggressive. They've got better rates. As I said, when I was talking about the client's opportunity, there's ILAPA and iStructure. ILAPA does have a cap. This new iStructure product has a no cap. So there are some real attractive options now for doing an attorney fee structure that are not just the plain Jane vanilla fixed income annuities. So the last topic today are qualified settlement funds, which are really important in certain cases from a settlement planning perspective, because it creates some time and space once a case has settled before decisions have to be made. And I'll explain why that is in a moment. A qualified settlement fund is a trust that's created pursuant to Treasury regulations that acts as a holding tank and allows you to settle a case for cash, even though structured settlements might need to be done for the client, or you might want to structure part of your fees. It can be done in a mass tort or single plaintiff cases. It gives you that time and space to plan, so you can make decisions about whether a structured settlement is going to be done, a special needs trust if that's part of the equation, a Medicare set aside. That can all be done out of the QSF, and it avoids triggering constructive receipt. Like if you had received that money into your trust account, that triggers constructive receipt, whereas the QSF can receive it and it does not trigger the constructive receipt. The drawback is it's got to be court created and there's some additional expense, but in the right case, a QSF makes a lot of sense. There are certain cases that sort of lend themselves to using a QSF. One is where there's multiple claimants and there's allocation issues amongst the different parties. If there's a case with multiple layers of coverage and you want to aggregate settlement dollars together, if there's complex lien resolution issues, public benefit planning concerns, structured settlements, again, whether it's the client or an attorney, or all the above. All the above certainly is a case where you'd really want to consider strongly using a QSF. QSFs are fairly straightforward to set up and administration. So it's basically a cash settlement between you and the defendant. You execute a cash release. The consideration is the payment to the QSF, and the settlement check gets made payable to the QSF. You petition a court, and it doesn't have to be a court that has jurisdiction over the matter, although that's most typical, to get an order that creates that QSF, and the funds are held in that QSF without violating constructive receipt until allocation decisions are made, liens satisfied, special needs trust or MSA is created, or the amount to be structured and the plan is decided upon. And then the QSF simply terminates once all the funds have been dispersed. Before we end today's webinar, I always like to finish with this image of our team, because we have this incredible team that deeply cares about our mission of improving the lives of the catastrophically injured. And I can't miss the opportunity to tell all of you how hard these people work to make sure that we are doing the best possible job for your client, making sure that either their lien is as little as possible, or their government benefits are protected, Medicare compliance is addressed, or all the things I talked about today about settlement planning are handled at the highest possible level. There are a variety of ways that you can leverage Synergy as an expert and efficiency partner for your law firm. One is having us help with healthcare lien resolution, whether it's ERISA, Medicare, FEBA, military, Medicaid, whatever it might be, dealing with Medicare compliance, handling the government preservation issues that can be very difficult and sticky, complex settlement planning, which I talked about today, attorney fee deferral, and then if you represent a class of plaintiffs that have been injured in a mass tort or a small group settlement, those are things that we can assist with. If you have any questions about the materials I covered today or anything at all about Synergy, here is all of my contact information. Feel free to reach out via email or give me a call. Happy to always consult and be an expert partner to you and your law firm. If you want to learn more about how to partner with Synergy, call us toll free or visit Synergy on the web at synergysettlements.com. Thank you for tuning in to today's Third Thursday webinar.